One early November morning in 1974, everything changed for Madam EWUDZIWA. At Kotokraba Market in Cape Coast, she waited for transport to Accra. She was a diligent woman whose poultry business boasted more than 1,000 birds. She had an award-winning backyard that fed her family and gave her joy. She had no idea that this day would bring distraction in her life in ways that she could never have imagined. A jeep came along and she flagged it down. When it stopped, she noticed it was a police jeep. She nevertheless asked the fare. The driver, Constable Kofi Asare, charged her 2 cedis for herself and her luggage. She agreed and climbed in. Constable picked 3 other passengers at Anomabo, and then the nightmare began. EWUDZIWA will testify later that Asare drove at breakneck speed. The police jeep tore down the road at a terrifying pace. EWUDZIWA kept telling him to slow down, her voice growing more desperate with each plea. He would ease off briefly and then go back to accelerating again on the highway, explaining that he was sent from Takoradi to Accra and he was in a great haste to get back. Around Mankasim, perhaps worn out from her futile warnings or seeking a distraction, EWUDZIWA dozed off. To her shock and dismay, she woke up at Winneba Hospital, her body screaming in pain. Multiple lacerations covered her face, arms, and legs. Her right leg itself was mangled with lacerations. Her femur was fractured. Her entire world had collapsed in an instant. Apparently, the jeep had crashed into a stationary truck at Winneba Junction. She was transferred to Cape Coast Hospital, where she spent 5 months, then transferred to Korle Bu. Her nightmares deepened when the doctors in Korle Bu discovered that certain metal plates inserted at Cape Coast Hospital were improperly fitted. This infected her leg, filling it with pus. Her pain became absolutely indescribable. Her poultry venture had to be disengaged and severed. Her gardens died slowly, and everything she had worked for vanished completely. EWUDZIWA sued the Attorney General for negligence. She was aggrieved, and her logic was simple and straightforward. Asare was a state employee driving a state vehicle, so the state should be vicariously liable for his reckless actions. She presented evidence of her destroyed livelihood, her poultry farm, her income, her medical expenses, transportation costs, costs she made for tests, and reports that she obtained from the hospital. But then she made one crucial omission. She never joined Constable Asare to the action. The state fought back hard. They argued that Asare was in a frolic of his own, completely unauthorized to do what he did. So consequently, they bore no liability. Their story was that Constable Asare had been assigned to one ACP Tete in Accra. His job the day before the accident was a simple errand of dropping the ACP at church and taking a reverend minister to Adabraka. He was supposed to return the vehicle to the police workshop and pick up the ACP the next morning. Instead, he vanished to Takoradi without permission and returned with paying passengers, like some taxi operator. The state also claimed volenti non fit injuria. They argued that EWUDZIWA knew she was entering a police vehicle, not a passenger car, so she assumed the risk and was owed no duty of care. EWUDZIWA was asleep and so saw nothing of the accident. The state, however, tendered a station diary which painted a clear picture of the accident. At around 5:45 a.m., the jeep was approaching a stationary truck and Asare attempted to overtake. When another vehicle appeared from the opposite direction, he tried to apply his brakes. They failed, after which he smashed into the stationary truck with great force. The vehicle examiner's report was revealing. The vehicle's right panel was completely ripped off and distorted. The front grille, the steering rack, the windscreen were all completely obliterated. It was a total write-off. The examiner concluded that the massive damage was consistent with excessive speed. The eminent Justice Cecilia Kranzingadu of blessed memory had the unpleasant duty of determining the issues. The evidence was clear and it showed that Asare was indeed negligent. The jeep's extensive damage told an undeniable story of recklessness. Even a cautious driver, driving at snail's pace, who crashes into an obstacle that was stationary, would be presumed negligent. But the crucial question remained, was Asare acting in the course of his employment? Because indeed, the liability of the state was only vicarious, and for the state to be liable, there had to be some demonstrable linkage between Asare's activities and the state's work. The court ruled he was not. Asare was assigned to Accra and was not authorized to travel to Takoradi and come back with fare-paying passengers. The law is clear that a master is not liable for the misdeeds of a servant unless they fall within the course of his employment. The misdeed must be expressly or impliedly authorized, or the servant must be doing authorized work in an inappropriate manner. Asare was clearly on his own unauthorized adventure. On the voluntary defense, the court rejected it. The fact that EWUDZIWA knew that she was entering a police car did not make Asare's reckless driving acceptable, but the case was lost anyway. EWUDZIWA's action was dismissed. She had only sued the Attorney General, and they had escaped liability. As she joined Asare, perhaps she could have claimed against Asare, because Asare was found to be negligent. Justice Krantingado, nevertheless, made a humanitarian plea to the Attorney General. She painstakingly calculated full damages and recommended that the state pay at least a portion. Her reasoning was admirable. If Asare had not been employed as a policeman, he would never have had access to the vehicle that caused this accident and destroyed this woman's life forever. A woman who built a successful poultry business, who won awards for her gardens, who contributed to her community, was left with nothing because of a legal technicality. The law is the law. The man who destroyed her life faced no consequences. The system that employed him also walked away clean. The case teaches us two crucial lessons. First, always join all the relevant people in the lawsuit. EWUDZIWA's fatal mistake was suing only the Attorney General and not Constable Asare himself. Perhaps she was of the view that the state would afford to pay those damages. But had she added Asare directly, she would have won a case of negligence against Asare and perhaps received compensation that she desperately needed from Asare. When someone wrongs you, sue both the individual and their employer to ensure that you have every avenue for justice covered. Second, this case establishes an important principle about driving and negligence. The court noted that excessive speed alone on a highway is not automatically negligent, but a prudent driver must drive at speeds that enable them to effectively control their vehicle. Asare's speed became negligent, not because he was going fast, but because he could not control his vehicle when it mattered the most. When his brakes failed and he couldn't avoid the stationary track, his excessive speed transformed from lawful driving into deadly negligence. Speed without control is recklessness, and recklessness always destroys lives. Follow Super Law GH Studios for more real stories, real cases, real people.